Next up, we have City Attorney Dink. We have Public Official Liability Training and KOMAKORA Overview.
Thank you, Mr. Mayor. This is, the two agenda items are agenda items which are being presented at the request of our carrier, Midwest Public Risk. I think some of you who've been on the governing body a little longer than others will have seen this video that they suggest that we present. It's about a 15-minute video, and so we're going to go ahead and play that, and then I'm going to cover some slides which are, it is really Kansas specific relative to public official liability, and then also briefly touch upon the Kansas Open Meetings Act and the Kansas Open Records Act. So Renee, go ahead and start the video.
Oh, hello, Dan. Congratulations on being elected as a council member.
Thanks, Mayor. I'm real excited about attending my first meeting and being sworn in, although I'm a little nervous.
Nervous? About what? You were elected by a landslide.
Well, there are several things I'd like to accomplish, but I'll be the first to admit I have a lot to learn. I don't want to end up like former Councilman Smith. I want to have a successful term, but I don't want to end up being sued.
Hi, Dan. You'll be joining us tonight.
Hey, Bill.
Hi, I'm Margaret Taylor. I've been a council member here with the City of Cottonwood for 10 years and mayor for the last 2. During my time with the city, we have made a lot of progress, but also a few mistakes. Certain members of the council have created messy liability situations that have cost the city a great deal of money, hurt our public image, and stalled important projects. And in some situations, elected officials have paid personal liability claims out of their own pockets. The purpose of this video and accompanying handbook is to help you avoid the mistakes that can lead to liability and identify best practices that will allow you to be successful as an elected or appointed official. CIRSA presents In the Scope of Your Authority, Preventing Public Officials' Liability.
That's a lot of good information. Well, thanks, Bill. I'll see you tonight. All right. Oh, Mayor, do you have a few minutes to discuss some of those past mistakes?
Sure, Dan, come on in.
Thanks.
Have a seat.
Thank you.
You referred to Councilmember Patrick Smith. He promised during his campaign he would never allow Megamart to build a store in Cottonwood, and he was pretty vocal about it.
Stay away, Megamart! Stay away, Megamart!
I've had similar opinions about giant retailers, although I haven't been as vocal as Mr. Smith. Where'd he go wrong?
Well, I don't think he ever accepted the fact that as an individual council member, he really didn't have the authority to act on his own. That's why Smith was never able to get anything done. He was pretty vocal about the few issues he was interested in, but rarely worked to build consensus within the council. Dan, pretty much everything we do requires collaboration within the framework of our council. Elected officials can't get anything done as individuals.
I see your point.
So the first lesson is to think and act in terms of we, not I. Apart from a few duties vested in the mayor, the laws that govern our city don't give any powers to individual council members. We've got a diverse council with a lot of different perspectives, and we can only accomplish our goals by working together. Now that you've been elected, your role changes dramatically. You're no longer an outsider promoting your own agenda. You now have to work with your fellow council members to accomplish the city's goals as a collective body.
Let me ask you more about Councilmember Smith. The Megamart deal, it was approved by the council, although by a close vote. What problems did Smith cause?
Remember all of his anti-Megamart statements? When it came time for us to actually hear and act on Megamart's land use application, he should have recused himself.
So he shouldn't have voted.
That's right. He shouldn't have participated in the hearing or voted. Smith had made it well known that he was aligned with the Megamart opponents. When we're acting in a quasi-judicial capacity, such as when deciding on a land use application or liquor license, we must be fair and impartial. We can't do that if we've already made up our minds before the hearing. Councilmember Smith had made it clear that he opposed the Megamart application. He was not acting as a fair and impartial decision maker. Fortunately, the Megamart application was approved by a small margin. Otherwise, the city could have been accused of a due process violation.
Due process?
Yes, the U.S. Constitution guarantees the right to a fair hearing as part of an applicant's due process rights.
During my campaign, I talked with a lot of my neighbors who are also anti-growth. I expressed to them my concerns about protecting our small businesses from giant retailers. Will that prevent me from voting on similar issues?
Well, the question is, if one of those big retailers comes before the council with a land use application, can you be fair? Can you make your decision based only on the evidence you hear and the requirements of our land use code? And can you set aside your previous discussions with your neighbors?
I can't ignore my neighbors. They elected me to represent them, not ignore them.
I'm not saying ignore your neighbors, but when an application is pending, you should not have discussions with anyone outside of the hearing. Our city attorney calls these discussions ex parte contacts. Your decision in a quasi-judicial matter must be based on the evidence presented. So when your neighbors want to speak with you about a pending application, explain to them it's inappropriate for you to talk about the issue outside the hearing. Suggest that they come to the hearing so their concerns can be heard.
Well, last year I called Councilman Miller and asked him to vote no on the pit bull ordinance. Did we engage in an improper ex parte contact?
No, that was a different situation. The council's consideration of a pit bull ordinance was a legislative matter. They were not dealing with the rights of a specific applicant under an existing law. The council was considering a new citywide law, so they were acting as legislators. Lobbying and other ex parte contacts are acceptable in the legislative context. But when you're in a quasi-judicial role, you've got to think and act more like a judge and refrain from engaging in or allowing ex parte contacts.
It makes sense when you put it that way. It's important not to base my vote on my biases or prejudice and only consider the evidence presented at the hearing, like a judge.
Exactly. The other thing to keep in mind is to make sure you have no conflicts of interest when you're voting. If you were appearing before a judge and you learned he had financial or other conflicts of interest, you'd expect him to recuse himself, wouldn't you?
Well, sure.
Well, people who appear before us in a quasi-judicial matter expect the same. To be unbiased decision makers, we must be free from conflicts of interest. If we do have a conflict, we need to declare it, recuse ourselves, and not participate in the hearing or decision.
I think I understand. I think I recall reading in the paper about another incident involving Patrick Smith.
Oh, that was probably the lawsuit involving our library expansion. The council had selected a very qualified contractor to manage the project. Smith was always hanging around the construction site, thinking it was his job to micromanage the project. Needless to say, Smith ended up in a verbal confrontation with the contractor. Things got personal, and Smith started talking to other council members about terminating the guy's contract. He also spread some vicious personal rumors around town about the contractor.
That wasn't very smart. Did he get the contractor fired?
No, but the contractor sued Smith personally for defamation. Our insurance company declined to defend Smith because it was alleged he was acting outside the scope of his authorized duties and acting in a willful and wanton manner.
So that's why Smith had to pay for his own legal defense?
Yes, he was not acting within the scope of his authority as a council member when he started those vicious rumors.
I heard he had to take out a second mortgage to pay his lawyers and a large settlement.
Smith learned his lesson the hard way. Being outside the scope of one's authority or acting in a willful and wanton manner will result in a loss of liability protections and insurance coverages. That's good, thank you. Now, Patrick Smith isn't the only elected official who's gotten himself in some trouble. Our former mayor, Joe Appleby, put himself in the middle of a personnel issue.
I think I remember this case. Tammy Williams was the director of Public Works, right? Didn't she try to stop sexual harassment in the street division?
What do you think about wearing something like that to work?
You guys are jerks, idiots.
Guys, I've told you about this before. You can't keep doing this. Bert, I need to see you in my office.
In trying to clean up the division, she fired the street supervisor, Bert Simpson. Mayor Appleby, who was drinking buddies with Simpson, was furious and made it his mission to get Tammy fired, and he succeeded.
You know, your job can't be replaced.
She brought a lawsuit claiming the mayor retaliated against her for trying to eliminate the harassment. The jury awarded her $150,000 in punitive damages that Appleby had to pay out of his own pocket.
Wow. What were the key lessons in this case?
First, don't act on the basis of personal motives. It was obvious Mayor Appleby wanted to fire Tammy Williams to get revenge for his friend Bert, and that was not in the scope of his authority. Second, we need to delegate personnel issues to the city administration. The council shouldn't be dealing with individual employees other than those who report directly to the council, like our city administrator. We should be focusing on the major legislative and quasi-judicial issues and leave administrative matters to staff. And third, never retaliate against someone for exercising their legal rights. Not only is retaliation against the law, but these claims are among the most difficult and costly to defend. We also had another fallout from the Appleby litigation. The press learned during the trial that Appleby was telling a lot of inappropriate jokes, and he was emailing them to the entire council. So the media demanded to see all of the council's emails over several years. Our city sure looked bad after the press got a hold of those.
Whoa, I didn't realize emails were considered public records.
Sure. While there are narrow grounds for not releasing them under some circumstances, the basic rule is that emails may be public documents that anyone can review. If you don't want something splashed on the front page of the newspaper, we need to keep it out of our emails.
At least we're not the only city making these mistakes. Remember the scandal involving Councilman Arnold over in Clarksville after he got stopped for speeding?
Yes, he was caught on television yelling at the police officer for stopping him. I cringed when he shouted at the officer, "Don't you know who I am?" Talk about an abuse of power.
Yeah.
And that brings me to perhaps the most important lesson. As elected and appointed officials, we must use our powers wisely and with civility. To misuse our position is absolutely improper and is not within the scope of our authority. We shouldn't try to put ourselves above the law or try to get some sort of special privilege because of our position.
Explain what you mean by acting with civility.
Well, as elected officials, we're perceived as holding the most powerful positions in the city. Because of that perception, our words carry a lot of weight. A harsh or ill-considered comment from any of us, especially if made public, can be extremely harmful to our employees' morale, as well as our public image. I once heard Appleby refer to our female employees as the staff hotties. It was embarrassing. Also, we should not participate in or encourage staff bashing in public meetings. We need to keep the focus on issues, not personalities. And then during Tammy's lawsuit, some of the jokes the mayor told during executive sessions were made public. We took another bashing in the press for those. Negative behavior like that can affect our entire organization. If we set a bad example at the top, we can't be surprised when it filters through the entire workforce. I'm so glad we've moved on from those days.
Well, this is eye-opening and a little frightening. Do we have any protections from liability?
Yes. Fortunately, we live in a state where our liability protections are strong. For one thing, we have an excellent Governmental Immunity Act. Our Public Officials Liability Handbook has a good summary of our liability protections. But to retain these protections, we must stay within the scope of our authority and not act in a willful and wanton manner.
You've used those terms before. What would be considered willful and wanton?
Well, the actual legal definition is found in the handbook, but basically, it's the kind of conduct that got Appleby in trouble. When he got Tammy fired, he was more than reckless in disregarding her legal rights, purposely trying to damage her career.
Do we have any other protections?
Sure, we have excellent personal immunities recognized by our courts when acting on legislative and quasi-judicial matters. But we do not have strong immunities when dealing with administrative problems. That's another reason why we need to stay out of administrative issues.
Got it. Let the city manager do his job.
And finally, we've got good insurance coverage, but that coverage only applies when we act within the scope of our authorized responsibilities and does not apply to punitive damages, as Mayor Appleby learned.
I see how these are all interrelated. Best practices, liability protections, and insurance coverages. And each area calls for us to meet certain standards of conduct. As long as we meet those standards of conduct, we should be okay.
I think you got it, Dan.
Thanks, Mayor. I really appreciate you taking the time to share your knowledge so I don't have to learn the hard way. Thanks for your insights.
You're very welcome. And one of the other best practices we've put into place is liability training. We hold a session every year for our council members, boards, and commissions. We have a session scheduled next month.
Great. I'll be there.
Great.
Hey, thanks again, Mayor.
Absolutely. Dan's a sharp guy. I think he'll make an excellent council member, as long as he follows these best practices. Think and act in terms of we, not I. When acting in a quasi-judicial capacity, be fair and impartial. Don't make up your mind before the hearing. Base your decision on the evidence you hear at the hearing and the applicable law. Don't participate in the hearing or the decision if you have a conflict of interest, and don't engage in ex parte contacts. Refrain from personal or retaliatory actions. Focus on key legislative and quasi-judicial issues and leave administrative matters to the staff. And maximize your liability protections by staying within the scope of your authority and avoiding willful and wanton conduct. I hope this video has helped you identify how to stay within the scope of your authority as an elected or appointed official, maximize your liability protections, and enhance your effectiveness as a civic leader. Good luck.
I know that video is hard to forget, so for those of you that have seen it, I'm sure it leaves a pretty permanent mark, but it does effectively communicate really a lot of the key points that I would want you to know. I am going to go through and cover some of the specifics that NPR asked us to touch on. They asked us to touch on Kansas Open Meetings Act requirements, Kansas Open Records Act requirements, and then I will have some specific references which really kind of expands on state-specific stuff relating to public official liability and really how it manifests itself under Kansas law. So I'm going to start with the Kansas Open Records Act. You know, I get a lot of questions, and probably the biggest question I get from public officials is, public officials are worried about their own personal text messages, their own records that they keep, as part of what you may just keep as part of doing business as a city council member, and whether or not any of that is subject to an Open Records Act request. The answer is no. There is a specific exception under the Kansas Open Records Act at KSA 45-217, and it's at subsection B there, to the extent that you all make records that you keep or maintain as a member of the governing body, then it is not subject to the Open Records, to the Kansas Open Records Act. That, however, you do need to be mindful. These are just what might be requested through an Open Records Act request. If we do end up in litigation, all of those materials can be subpoenaed. And in fact, for another jurisdiction that I represent, there was an Open Meetings Act complaint, and so the district attorney had subpoena power and in fact subpoenaed each individual council member's text messages to see whether or not serial meetings were occurring or not. So the mere fact that it's not, your texts, your records don't fall within the scope of the Open Records Act doesn't mean that they'll never see the light of day. So you need to be cognizant of that. The Open Meetings Act, I think you all have a pretty good grasp of what the Open Meetings Act requires generally. You know, this is the concept of the Open Meetings Act is that decisions that you all make need to be made under the light of day. That there's no secret processes that are occurring in smoky back rooms where decisions are being made. That's one reason why when we go into executive session, we can't take any action in executive session. You all can build consensus, but to the extent that formal action needs to be taken, it has to be taken out here in open session. So the Kansas Open Meetings Act, one thing that we always train on when we talk about the Open Meetings Act is you don't necessarily need to think about violations of the Open Meetings Act just in a meeting context. There are things that can happen, such as emails, such as serial meetings, such as staff meeting with each member separately to poll the member. Those are what are referred to as serial meetings, and those can be deemed to be violations of the Open Meetings Act as well. And in fact, the situation I was telling you about where council members' text messages were subpoenaed by the DA, that was the allegation in that circumstance, that there was communication, serial communication outside of the presence of a meeting, and it arrived at a preordained decision that didn't occur through interactive communication through a properly noticed open public meeting. So the key to the Open Meetings Act is interactive communication. So what that means is you all need to be having back and forth. Sometimes staff might push information out to you. That is not a violation of the Open Meetings Act because it doesn't involve interactive communication by you all trying to arrive at a decision. Where you get in trouble there is if you start hitting reply all and start discussing matters which are part of the materials that are being circulated. So you need to be cognizant of that. Meeting conduct. So I think a common misunderstanding of the Open Meetings Act is that it somehow provides requirements for the way that a meeting is conducted. The Open Meetings Act does not require that we have an agenda, does not require that we publish an agenda, but if we do have an agenda and we do publish it, it has to be generally made available to anyone who requests notice. Also, the agenda, we don't have to stick strictly to the agenda. You can change the agenda, you can vary from the agenda as part of the meeting. The Open Meetings Act specifically allows the general public to record the meetings, whether that be through a camera, through a recording device. The only requirement is that if the recording is disruptive to the meeting, so if somebody wanted to set up a video camera here where it would be disruptive, block views of people, then that can be problematic, and you don't have to allow the disruptive type of activity. Public meetings, there actually is no public right to speak at an open public meeting. That said, if you do allow a public comment section, the First Amendment actually doesn't allow us to make any content specific determinations. So if you're going to allow an open public forum where anybody can show up and say anything, then you really can't hem in what people are talking about within. I know the mayor always reads his statement at the beginning, provided that, someone, if you set a meeting rule that there's not going to be abusive type of language, no profanity, things like that, then that is permissible time, place, and manner restriction. The location of the meetings have to be accessible, and then of course we talked about the no secret ballots. Executive sessions, again, no binding action can be taken. We talked about the fact that you can build consensus. The motion, you guys have done enough of these, but there are specific requirements. You're supposed to cite to the provision of the statute that you are moving into executive session under. You have to state the time that you're going to reconvene the meeting. You cannot reconvene the meeting prior to that time. So sometimes we have to sit here for a little bit until that time comes around. And the reason for that is because when we come back from executive session, just like what I said there, you don't have to set an agenda. You all literally could take any action that you could take at a public meeting. And so if you came back early and someone left, then they wouldn't know what time to come back where you could again take binding action. So that's the rationale for that. Okay, the Kansas Tort Claims Act, this really, the exceptions to liability under the Kansas Tort Claims Act, the video talked about the Colorado equivalent to the Tort Claims Act. Really, the same types of provisions exist within the Kansas Tort Claims Act relating to liability. Liability under the Tort Claims Act is the rule. Probably the exception that is most appropriate or would apply to most of what you do is that you all have immunity for engaging in legislative functions. So that includes obviously, taking action or failing to take action, including the speech and debate clause of both the United States Constitution as well as the Kansas Constitution protects what you say up there from the dais. Personal immunity for municipal governing body and appointed board members. There's a provision under the Kansas Tort Claims Act that basically says as long as you are acting, and this is what they said in the video too, right? As long as you are acting within the scope of your office and you're acting without actual fraud or malice, then you cannot be personally liable for negligent or wrongful acts or omissions as a governing body member. If that doesn't mean you can't subject the city to liability, but in terms of being held to account as an individual where you could be individually on the hook, then the Kansas Tort Claims Act does provide you with some protections there. The Kansas Tort Claims Act also requires that to the extent you are acting within the course and scope of your position as a governing body member and the city does get sued or you get named individually in the suit, the city is compelled to come in and indemnify you and provide you with a defense, meaning hire a lawyer for you. Again, the exceptions to that would be what they talked about on the video. If you're acting outside of the scope of your authority, or if you're acting, in this case, with actual fraud or malice. Actual fraud or malice, pretty much no insurance policy out there is going to cover fraud. Same with punitive damages. There's no insurance policy out there that is going to cover a claim for punitive damages. So this is the Tort Claims Act. There is a specific provision that municipalities can't be held liable for punitive damages. So there is that protection under the Tort Claims Act, and there is a cap on damages of $500,000. So there are potential federal claims. In the video, you heard them talk about a claim where someone was sued for due process violation. That would be a claim under what we refer to as Section 1983, which is basically a statute which allows individuals to bring lawsuits based upon alleged constitutional violations. So whether they're claiming First Amendment, equal protection, due process, whatever that may be, Section 1983 gives an individual a vehicle to seek monetary damages. Unlike the Tort Claims Act, you can be named individually under under a Section 1983 claim. And the reason why people would name individual actors under Section 1983 is because you cannot get punitive damages against a municipality under federal law, even for constitutional claims, but you can get them against an individual. So it's very common in constitutional claims that an individual actor, I see this all the time in police misconduct cases where the officer is named because they're seeking punitive damages, and they can't get it if they just name the municipality. We do have some protections. Qualified immunity is a defense to constitutional claims. Basically, the concept of qualified immunity is that it provides an affirmative defense as long as your actions were not motivated by bad faith and there is a reasonable basis for your actions. So an additional standard which applies under qualified immunity is you are entitled to qualified immunity as long as your conduct is not in violation of clearly established law. So clearly established law means there's got to be a case pretty darn close to on point, usually from the U.S. Supreme Court, or we're in Kansas, we're in the 10th Circuit Court of Appeals, where there's a specific case where you should know, based on the holding of that case, that the action that you took was in violation of the law or not. As long as you don't violate those standards, you're entitled to qualified immunity. Qualified immunity actually isn't just an immunity from liability, it's an immunity from suit. So you can raise that early on in the case and get the case kicked out even before, we get into things like written discovery and taking depositions and things like that. So it is a powerful protection. And the philosophy as to why qualified immunity exists, why the U.S. Supreme Court, it's a concept that's gone back decades and decades, is that if you didn't grant qualified immunity, you would discourage people from engaging in public service. So I think that's the presentation. If you all have any questions, be happy to try to field those for you.
Thank you, Ryan. Council, have any questions or comments? Are they coming out with a newer video at any point? Older?
The featured VHS tapes in the video really aged it a little bit.
Pager? It was good information.